morning and welcome from the Senior Law Day Collaborative. My name is Elena Falcone. I'm the Director of Outreach Programming at the Westchester Library System. I am also a proud co-chair of the Senior Law Day Collaborative. I share that role with attorneys Sarah Steckler of Keene & Bean and Melinda Bellis of Legal Services of Hudson Valley. The Senior Law Day Collaborative is composed of more than 150 professionals who are all eager to bring authoritative information on legal, financial, and health topics to our county's older adults, especially in these challenging times. To that end, I want to call out a few features of our program's website, seniorlawday.info. Seniorlawday.info, you can see the URL at the top of your screen, has information that you may be able to use today to answer questions that you are holding. You'll note that to navigate the site, we have across the top a menu that has a calendar of all of our upcoming events, including more of these webinars. We have a page that has recordings of webinars that have already taken place this year, as well as content from prior years' programming that is still current and relevant to you. You'll see videos, you'll see presentation decks, and a lot more information. Also, that's something I really want to call out is that we have the full text of our annually updated publication, the Elder Law Q&A. This publication is available both in English and Spanish, and it is fairly easy to navigate and covers a lot of critical topics that may be of interest to you today. Also on the website, when you return to the home page, which will clearly take a second, you'll see that there is an Ask Us button actually on every page of the site. The Ask Us button is where you can ask questions, not just today, but any day of the year, and we will tap our team of 150 collaborative members to get their expertise applied to your question. Remember, the seniorlawday.info and the Ask Us button is always available to you. I will now turn the screen over to Stephen Schurkman. He is an attorney and a principal member of Keene & Bean with offices in White Plains. He is also one of the founders of the Senior Law Day effort.
Thank you, Elena. It's my pleasure to have been invited to speak today and on a very important topic, which is things that you should know and get done relative to preparation of a will and other documents, or the title that you more cleverly came up with, which is Should You Get Your Will Done Now and How? And we're ready to get going here. What I want to talk about first are the estate planning documents that I'm going to speak about. And they are the principal documents that are part of an estate plan when you're putting together your estate plan. And they are, first we're going to talk about powers of attorney, then healthcare advance directives. We're going to talk about a trust and talk about a will and why sometimes you use a trust versus using a will. And we're going to tie all of this into the fact that Governor Cuomo, over the last 2 weeks, has issued certain executive orders allowing people to now get their wills signed by video or virtually, and do not physically need to be present in front of a notary, and does not physically need to be present in front of witnesses, but instead it can be done by video. So this is a very important development, particularly in light of the coronavirus. And my hat's off actually to the Governor Cuomo, the legislature, whoever was responsible for the concept and putting together this executive order, because I think it will be of enormous help to the public in terms of getting documents signed now, if you want to get them signed. Because attorneys, as you may not be surprised to hear, particularly estate planning attorneys, are deemed to be non-essential workers right now, and our offices are closed. But there are still ways to connect to us by email and otherwise. And we are busily preparing documents for our clients to sign even during the COVID-19 crisis. So let's talk first about powers of attorney. That is the principal financial planning document that everyone should have when putting together their estate plan. Why do you need it? You need it because if there ever came a time when either you weren't able to handle your financial affairs or you were not in a position that you could take care of them yourself, you want to make sure that you've appointed somebody who can take care of your financial affairs in that circumstance. And the power of attorney is the document that allows you to appoint someone called an agent to handle your financial affairs. And it's very important to have that document when putting together your estate plan. A lot of my clients will say to me, why do I need a document if I just have a joint account with somebody else? They can access my assets, they can pay my bills, they can take care of my financial affairs and transfer funds and do whatever is needed as I would do it if I just have a joint account with them. They have the same power that I do. And that's true. If you've given somebody a joint authority over an account, they can access assets that way. However, what people lose sight of is the fact that a power of attorney is a document that can only be used during lifetime. And a joint account, however, is a document that gives the survivor the right to inherit the assets when one party passes away. So if you're using a power of attorney and you have a joint account with somebody, if you pass away, the one giving the power of attorney out, that person passes away, well, everything at that point is going to end, and that the process ends and a will or a trust takes over. Instead, if you had a joint account with somebody, what would happen is the principal dies, and now the joint owner, is the surviving owner, actually inherits the assets. And that may not have been your intention. So you could have an example where you have a will where you have, let's say you have $600,000 and you left in your will 1/3, 1/3, 1/3 to your 3 children. And then you pass away, yet the funds were being held in a joint account for one child who lived nearby and was helping out and had a power of attorney from you. And what happened in that instance was that that one child inherits everything because you had them on the account jointly with you. Jointly held assets supersede the terms of a will. They supersede what happens to assets at the time of your passing. Instead, the assets are distributed in accordance with the fact that there is a surviving party. And that may not be the intention. And power of attorney is used because you give somebody power, but you're not giving them the authority to inherit the asset. So very, very important there. Who do you appoint as your agent? Well, you want to appoint somebody who you trust implicitly because you're giving them unbelievable authority over the assets. So it needs to be somebody who you trust. You can name more than one party. You can have multiple parties acting as the agent. You can have a primary agent. You can have a successor agent. You could set it up really any way that you want to. Question, should the agent be compensated? Well, if you have somebody taking over your financial affairs, you may want them to be compensated. It's a big job to take on, and it's important to consider whether or not you want, in fact, your agent to take remuneration if they want to. Many times in family circumstances, nobody will be compensated because nobody wants to accept compensation. But giving the option for the agent to be compensated, I think in most instances makes good sense to do. Very important with powers of attorney. You can limit them. You can make them a general power of attorney. You could make it so that the power of attorney allows the person that you're appointing, that agent, to do anything and everything under the sun as relates to financial affairs. Or you can limit it. Perhaps you just want to appoint somebody on a power of attorney to handle your real estate closing or just do your banking. You can limit the power of attorney and streamline it and tailor it that way. So you have options as to how you want to use it. When we do general estate planning, frequently the power of attorney will give the agent broad authority, but you have to make sure you're comfortable giving them broad authority. One component of power to consider giving an agent is a gifting right. And many of my clients will get very, wow, giving my agent the right to actually give away my assets. Do I want to give them that much authority? Because that's really a big deal. And what happens is in giving an agent that level of authority, you have to have a separate document called a statutory gift rider. And that would attach to the power of attorney. And you can reference right in that document who is the group of people that you want your agent to be able to give your assets away to. If you're not able to manage them yourself and you want certain people perhaps to be benefited, and under what circumstances you want those assets to be transferred. Usually the standard is that you can attach a gift rider and allow your agent to do gifting if they believe it to be in your best interest. However, it's also important to maybe be a little bit more specific and say that you want the agent to be able to do gifting if it's to reduce to benefit your economic circumstances by reducing tax liability, or maybe in the context of if you were trying to qualify somebody for Medicaid, it's important to allow assets to be gifted away from you so that the person could qualify for Medicaid benefits and get below the Medicaid threshold to financially qualify. So having a gift rider attached to your power of attorney, if you implicitly trust your agent, can be extremely beneficial. I just want to talk, the last point on powers of attorney is how are they signed? A power of attorney must be notarized, and we're going to talk at the end about the governor's executive order as relates to all of these documents and how a notary can act under the current circumstances, not being physically present. But the gift rider, believe it or not, has to be witnessed and also has to be notarized. So I'd like to move on to healthcare advance directives.
Steve, can I ask a question?
Oh,
we have questions from our Senior Law Day Ask Us button, and I wanted to, one of them is just a question about power of attorney. How can a power of attorney's authority be limited? So you mentioned, things that you can specify that they can do. Can you specify what they can't do?
You can. In the power of attorney document, it can be, the format is drafted in a way where they'll list a variety of different options that you have in terms of what you will want to allow the agent to do. Do you want to give them banking authority? Do you want to give them authority to do real estate closings? Do you want, you can vary, so you can put your initials and specifically limit the power of attorney to those authorities, or you can check off a box that says any and all actions referenced in this power of attorney, which can be extremely broad.
Thank you.
Sure. Okay, on to healthcare advance directives. Here there are a few, as you'll see on the list here, and I just want to lead off with the healthcare proxy because that is probably the most important document in the group. And in the healthcare proxy now, like a power of attorney, you're appointing somebody to make healthcare decisions for you if you cannot make them yourself. And here, again, you're appointing, like in the power of attorney, you were appointing a financial agent. Now you're appointing a healthcare agent. But the difference with appointment of agents in a healthcare proxy is that people must be named in succession. So you appoint, perhaps Mary is first, and after Mary, then it's Tom, but you can't have Mary and Tom together. The public health law in New York State discourages that, and you should be aware of the fact that this is one time where you really have to name people in succession. Unlike other documents, a power of attorney or in a will where you're naming two executors together, you can do that. A trust, you can have two trustees. Power of attorney, you can have two agents, but in a healthcare proxy, it's one at a time. And you're giving them the authority over your healthcare if you can't make your own healthcare decisions in terms of whatever needs to be done to take care of you, including withholding or withdrawing life support if you have indicated to the healthcare agent during your lifetime that you would want you would want to give them the right to do that, and have of course made them aware of what your feelings are in connection with end-of-life planning. Related to end-of-life planning, some clients will sign a separate living will document. And a living will is a statement of your intentions with respect to your medical care, and frequently talks about the withholding or withdrawing of life support, and can give direction there as well. So it gives the healthcare agent who you've appointed in the healthcare proxy the authority to make decisions about end-of-life planning. If it's spelled out in a living will, it gives them some guidance as to what you may, what your intentions are in that area. If you're silent on the issue of end-of-life planning, then it's really up to the agent to make decisions based on what they think you would have wanted. It's called substituted judgment, and they can enter that substituted judgment in your best interest. But of course, they could be challenged by another family member, perhaps, in which case not having the living will statement may make it difficult for you to carry out those sorts of wishes. There's another document that has come into being in the last 10 years or so called a MOLST form, M-O-L-S-T. It stands for Medical Order of Life-Sustaining Treatment. And you're finding these documents used more and more often when somebody is in a hospital, or somebody is in a skilled nursing facility, or and what it is, it's a document that's signed by you, but it's also done in consultation with working with your doctor or a nurse or PA in that office, and the physician will also sign this document, which indicates what your end-of-life planning is, making it a doctor's order. It becomes a medical order. So if you're in a hospital and you and the doctor have signed this document, it has a lot of effect in terms of making sure that your intentions are carried out. So it can have instruction in it, such as do not resuscitate, do not intubate, under what circumstances nutrition, hydration, respiration is to be provided, and it's all signed off by the doctor. And many clients have used these forms, and it's something to consider. The Health Insurance Portability and Accountability Act, or commonly referred to as HIPAA, has a release document that is a good document to consider as part of your estate plan. We spoke before about healthcare proxies. Healthcare proxies where you're appointing somebody to make your medical decisions if you can't make them yourself, so that person is your decider. But sometimes you want more than just a decider to be able to get information about your medical condition from a physician, a hospital, or other medical system, so that they can understand how you are doing and confer with the person that you've appointed in the healthcare proxy to make healthcare decisions, which they can give input on and help the healthcare agent to make good decisions related to your healthcare. So in the healthcare proxy, you're appointing the person who makes the decision. In the release form, you would certainly include that person, but you would also may want to include other people who you would want to be involved with conferring with the healthcare agent in making decisions about your healthcare going forward. And that's the purpose of the release. It's so that medical information concerning your condition can be released to others and discussed with others. So that's another important document to have in your array of estate planning forms. It's referred to as a healthcare advance directive, one of those. The disposition of remains document Now, that's a document that's come out of New York State only in the last 15 years or so. And it came about because people would want to set forth what they want as how their remains are to be dealt with at the time of their passing. And they would say, they would put provisions in a will, for example, to say, I want to be cremated or I want to be buried. So those are your healthcare advance directives. Healthcare proxy has to be witnessed by at least 2 people. Same for the living will. The most form is just you and the doctor sign together. And HIPAA remains documents requires the signatures of witnesses as well. So when we get to the end again, witnessing, notarization, how do we get that done in today's circumstances?
Thinking about the different topics that you've just covered, one of the questions that we've had that has come in is someone is saying, and I share the question. I'm healthy now, but I'm worried about a family history of dementia. So, am I correct that if I want to ensure that my family member is that the one who's named as the healthcare proxy, I guess, follows my wishes regarding end of life care, I need to do that living will? And it seems like the MOLST makes that even more clear. Is that correct? Like it's kind of a sequence of authority?
If you want to have instruction in the context of you have a family history of people having dementia, you can get guidance from the Alzheimer's Association in terms of the sorts of issues you want to make sure that get covered in your living will instrument. And that would be a good thing to do, and I've had a lot of clients who've done that. The MOLST form is just a directive really towards end of life, talking about DNR orders and DNI orders, do not intubate orders. It's usually it's much more directed as to medical procedure, and where the living will is speaking more in detailed terms about what your wishes and intentions are.
So
that clarifies it.
Is the MOLST something that is created at the hospital in the context of a specific illness of an event, or is it something that you actually can prepare well in advance?
You can prepare it in advance, but when you look at the MOLST form, it has, where you can write into your MOLST form certainly the same sort of language you would write into your living will as relates to dementia, for example. You could put that into your MOLST form. Okay. But you want to have something at your bedside, so to speak, whether it's in a hospital or a nursing home or other assisted living facility, that if somebody needs to make a quick decision, whether it's do not resuscitate, do not intubate, decisions about withholding hydration, nutrition, respiration. This is kind of a very quick order that, and it's signed off by a doctor that somebody can rely on.
And
so the point is, yes, you can do a MOLST form in the community before you're in a hospital or a nursing home. Yeah.
And are these documents that you should, so that one you should have at the bedside at some point, but where should these documents be kept? Because they seem like they're ones that you're going to need suddenly.
Okay, these documents should be kept, in my view, in several places. Certainly, number one, you want to make sure that the party who you've appointed, like in the healthcare proxy, for example, is also in possession of the document. In addition, you should have the documents, particularly if you're living alone. The suggestions are often been made to clients and apparently EMTs are instructed this way. They come into an apartment and somebody is not compos mentis, is laid out. They will look at the front of a refrigerator to see if documents are actually, there's a it's called like an end-of-life vial or something. There are different terminologies for it, where you can just make your document readily available there. You can have, there are cards that you can use for healthcare proxies and put language in that. You can carry in a wallet. You can certainly have a digital version of your healthcare proxy that you carry around with you, and we certainly send digital versions of all documents to our clients now, but you just try to make it as available as you can.
Thank you very much.
Thank you for that question. Okay, my pleasure. On to wills and trusts, and that's slide 9. And what I want to talk about, everybody generally understands what a will is. It's the document that you use to make distributions of your assets at the time of your passing. But many times what I find with clients is that they don't know what a will controls in terms of their assets. In other words, a will does not control assets that you own jointly with another person. We spoke about that a little bit before with powers of attorney. Instead, with a will, only controls assets that are in your individual name, that do not have a beneficiary, that are not jointly held, that are not in a trust. So what I mean by that is, if you have an account with someone else that you own jointly, when you pass away, no matter what you write in your will, that account is going to go to the surviving joint owner. If you have a beneficiary designated on an account or on a retirement account that comes up frequently, or in life insurance that comes up frequently that you've named a beneficiary, you can write until you're blue in the face in your will that you want those assets to go to the beneficiary. But in fact, I'm sorry, you can write in until you're blue in the face, you want it to go to certain individuals, but it's going to go to the beneficiary designated on the beneficiary form. That supersedes the will. So it's important to understand, what does a will control? It controls assets that are in your name alone that do not have a beneficiary. And what is probate? Because people always hear of probate in the context of using a will. Well, probate is taking the will at the time of your passing and bringing it to the surrogates court in New York State. That's the court that handles wills and trusts. And to have the will approved by the probate judge, the surrogate judge. And that approval includes having an executor appointed of your will, the one who takes over and manages the settlement of your estate, and making sure the beneficiaries are paid, and making sure your tax returns and taxes are filed. That's the executor's responsibility, and that person gets appointed as part of the probate process. Probate costs. In New York State, the highest probate fee charged by the state of New York to have the will approved and the executor appointed is $1,250 for estates that are valued at $500,000 and above. And then there's a sliding scale down from there. So many clients will say, gee, you know, do I want to pay the $1,250? Maybe I'll use a trust instead. Usually I indicate that it's a relatively modest amount, in that in order to make your estate non-probate, you might need to involve a trust, which I'll talk about momentarily. And that can be a much more costly undertaking in terms of the attorney's fees to be paid to prepare a trust. Taxes in New York State, and this applies both to wills and to trusts. New York State does have a separate estate tax. Federal government has an estate tax, meaning that has been referred to in recent years as the death tax. But the federal government says that you're not taxed. There is no estate tax imposed on your estate until you have an estate valued at over $11.58 million. So that excludes probably 99-point-some% of of the U.S. population. New York State and about a dozen other states in this country have separate state estate taxes, and in New York State, that threshold is $5.85 million currently. To the extent your estate is valued at more than that, there would be an estate tax to pay unless you are leaving your assets to your spouse, or to charity. Of course, if you're leaving it to your spouse, then when that spouse subsequently passes away, that tax, to the extent it's over that threshold amount of 5.8 million, would have to be paid, unless, of course, we had a spouse who was engaging in serial marriages or something like that, which is my attempt at being a little humorous here. Elena, looks like there's a question there.
No, I do have one. If thinking about the differences between an asset that goes into a will and something that is jointly held, if my will provides for all of my assets to pass to my spouse, and I have a joint bank account with my daughter, who gets the funds in the account when I die?
If you have a joint account with your daughter, that will countermand the terms of the will or the trust. It's the beneficiary form itself that controls. So it's true for a joint account. That's true if the joint account status controls and countermands a will or trust.
Thanks. I wanted to check that. Thank you.
Okay, sure thing. Okay, so that's, those are the rules related to wills, but you should also be aware of trusts as an option to handle your estate planning, your planning of how your assets are to be managed while you're alive, and the trust also can talk about what happens to your assets at the time of your passing. And many clients will find the trust as a desirable document to use because it's a mechanism where they can have assets that they have to contribute to the trust now handled during their lifetime and give direction at the time of their passing. But let's talk about what a trust is, because people are less familiar with a trust instrument than they are with a will. And a trust is a document which is really, a trust is an agreement where the person who has established the trust, created the trust, that person is frequently, you'll see them referred to as the grantor or the trustor or the settlor or the creator, and you hear all those ors. That's the person creating the document, enters into this trust agreement with someone called the trustee, and that's the person who manages the trust. That person can be the same person who establishes the trust. You can set up your own trust in the name of Don Jones, and Don Jones can be the grantor, the one who establishes the trust, and he can also be the trustee. And trusts can be revocable, or they can be irrevocable. So you can have a trust that you set up, and just like a will, you can change it 3 times a day if you wanted to do that. Or you have a trust that is irrevocable, where you can't change the terms of the trust once you set it up. And those are sometimes used in the tax world to reduce tax liability, but they're also frequently used in the context of asset preservation planning should somebody be looking to qualify for Medicaid. Because an irrevocable trust is where you're taking assets and putting them away from you irrevocably. You move them away so that you can qualify potentially for the Medicaid program. So irrevocable trusts, you'll usually see them used in the context of tax reduction planning or asset preservation planning for purposes of qualifying for Medicaid. And they can be really very, very beneficial. The times where I find trust to be particularly useful, because many times we'll use wills because the probate process can be pretty straightforward in many circumstances if you're leaving your assets to your next of kin. So if you're survived by a spouse and children, for example, if those are your closest relations, and that's who you're leaving your assets to, a will can work just fine. But sometimes if you're bequeathing your estate to people other than your next of kin, let's say your closest relatives are nieces and nephews. And let's say you have 6 nieces and nephews, but you only want to provide for 2 of them. And you want to make no provision for the other 4. Well, you can certainly do that in your will. You're entitled to name anybody who you want to be your beneficiary. However, part of the probate process, which only applies to wills and not to trusts, requires that you give a copy of your will and an opportunity to object to everyone who is your next of kin, the people who would inherit from you if there was no will at all. Because those are the group of people who, if they object to your will and they are successful, they will inherit from you because they've knocked out the will, and now the assets are passing to the next of kin, which is them. So sometimes if you're leaving your assets to people other than your next of kin, and sometimes this comes up even in the context of somebody who has, they're excluding a child from the process, we will use a trust so that we don't have to go through a probate process, showing the party the copy of the will, what it says, the exclusion, and giving the party right then and there the opportunity to object. That doesn't mean the party can't object when you use a trust, but a trust is a private document, and it's much more difficult to contest, and it is not made readily available to next of kin and people who haven't been provided for. So in that sort of a circumstance where you're not leaving your assets to next of kin, sometimes we'll look to a trust instead of a will. Another place where we use trusts instead of wills is when somebody comes to me and says, gee, I have, I own my home in Westchester, and I also have a winter residence in Florida. I have property at the Jersey Shore. I have something outside of New York State, real property outside of New York State. And there we'll use a trust because the law says that you have to probate your will in every state where real property exists. And in that circumstance, we look to deed all of the property into the trust and avoid probate in multiple states. So that's another time we'll see it used. In addition, you'll see it used for privacy purposes generally. A will is a public document once probated. Okay, it stays a private document when you signed it until date of death, but once that will is submitted to the court, it becomes a public document. Some people are very uncomfortable with that fact because anybody can request to see it. Also, another benefit of trust, people will like trust because they're not held up by the probate process. It's a private document. Someone passes away. The trustee is in control and continues to manage the assets at that point, and that is what happens. So a trust can be very useful, and we're going to now talk about how do we get these estate planning documents signed. And I'm talking about when does a document need to be notarized? When does a document need to be witnessed? Okay. A question? Yes.
A question. This is a very contemporary question, I guess. Thinking about all of the passwords that we have in hand for different digital things like our Facebook account or our email passwords and other things. I was under the impression that there was some place where those are specified, like who has access. Is that in a will or a trust?
Digital assets. Okay. We have clauses in terms of where the digital information is located. Was that the question?
And who can access it? Who can access it? So do my passwords need to be listed?
Okay, great question. No, your passwords certainly don't need to be listed in the document, nor would I encourage you to list them in the document. However, what is important is that your power of attorney, your will, your trust. Okay, power of attorney is a document that operates while you're alive, will when you're deceased, trust when you're alive and when you're deceased. And in all of those instruments that you have a digital assets provision that says that your executor or your agent in the power of attorney or the trustee of the trust has the authority to get access to your digital information. But most important, I advise clients, please make sure that the person that you've appointed as your executor, your trustee, or the agent in the power of attorney knows where that information is so that even though you've given authority to those people to go to get the information from wherever they need to get the information from, that's going to be a process. Entities are very proprietary about giving out that information, and they make it difficult. And even though we have you appointed with that authority, you're going to lose a lot of time being able to get access to digital information. So have the provisions in the will, the trust, the power of attorney, but tell those people where the information is.
Are we also supposed to be specific as to what they're to do with it? For example, take down the Facebook account.
You could be that specific. You could give direction in that respect. These sorts, I mean, you can give instruction, about virtually anything you want to do in a will, but generally you should be having discussions with people as to what your intentions are. Okay.
Thank you.
I'm going to wrap up by just talking about how these documents get signed. All right. And certain documents are signed before a notary, and there we're talking about the power of attorney. In particular, that's a document that has to be notarized. And then we have documents that are signed before witnesses, such as the health proxy, the living will, the disposition of remains document. Those are signed, and then they have to be witnessed. So how do we get that done? Particularly in today's world where we can't, social distancing is the norm. What do we do? Well, you can, under the governor's executive order, have a virtual signing this way by doing it as we're doing now. I'm on Zoom talking to you. I could be on Zoom talking to you with your will in front of you. And we could have also on the Zoom a notary public and or witnesses who can be observing what it is that you're doing, and use the same procedures that we use when we see you in person. So if it's a notarization that's going to occur, if the notary does not know you personally, then they should be asking for identification information. The witnesses, same thing. If the witnesses do not know who you are, then they should also be receiving identification information, whether it's a driver's license or some other photo ID that frankly needs to be either emailed or faxed or whatever over to the person on the day that the document's being signed, showing who it is that they are notarizing or witnessing. Also on that, as part of that procedure, the document is signed before the notary, and the signed document is then again emailed or faxed to the notary or the witness, and the notary or witness will then sign the document at their end, and they need to do so the same day as you signed your will or power of attorney or trust or healthcare proxy. That notary, if it has to be notarized, or that witness has to sign the same day, and they should also email, fax, or otherwise get back to you a signed copy of the document, although the governor's order doesn't say that has to happen the same day. But presumably, if you got documents going back and forth, it would happen the same day. If it's a notarization, the person who is signing does have to confirm that they're a resident, that they're located in the state of New York at the time they are signing the document. Thereafter, the original documents can also be forwarded to the notary or the witness to be again notarized or witnessed if you want to have original signatures on everything. But the digital signature is sufficient in and of itself, whether or not an original document is ever ultimately signed by the signer and the notary or witnesses together. So this is this executive order is truly a very thoughtful order that's been delivered by the governor to allow people to make sure that they can still advance getting their estate plan done during this time. They can have their powers of attorney, health proxies, living wills, trusts, all signed now. I've just, it's a pleasure to be able to speak with everyone today. Is there any closing questions, Elena, that people may have?
Well, I guess a question and a comment. One, I want to remind folks again that we have that wonderful Senior Law Day website, seniorlawday.info, and it has the elder law Q&A. And much of what you've covered is in part addressed there, though you've given it a more, you've sort of seasoned it with comments about what's happening now, particularly in how these documents can be signed. And I'm just curious if you, I mean, the situation I guess we're trying to avoid is some of the challenges that are taking place now in nursing homes and assisted livings. Can what you just talked about be done in a nursing home or assisted living? I guess maybe as long as there's video access, but I know many of those places don't have that for their residents.
Yeah, there has to be video access. Without video access, it's not really possible to get this done pursuant to the governor's executive order.
So that would mean someone on staff or the resident themselves needs to have a cell phone that has FaceTime. I mean, at minimum, that's what we're talking about.
That is what we're talking about. But it's an improvement over not even having this ability to get documents signed. It's a vast improvement, and I'm not actually aware of other states that have similar orders at this point. So kudos to New York.
Yay, in many ways.
Yes.
So again, Steve, thank you so much. I'm gonna flash up on the screen once more a picture of our website. Hopefully, if I can shoot over there, we have the Senior Law Day Collaborative, seniorlawday.info. The video of today's presentation will be posted to this website as soon as we can, probably by the end of the day, if not tomorrow morning. And the elder law Q&A that I was referencing is available here as a guide for you to follow, to learn more about many of the topics that Steve just reviewed for us. And don't forget the Ask Us button. If you have a question that occurs to you later on today or anytime in the ensuing weeks and months, you can click on that button and it sends an email directly to the collaborative, and we tap the expertise and knowledge and the compassion and wisdom of all of our 150 members to get an answer to you. So with that, thank you very much, Steve.
My pleasure. Thanks for inviting me.